Good afternoon, everyone. My name is Ron Skinner. I'm the Director of Association Resources here at NAA, and it's my pleasure today to welcome you to this Independent Rental Owners Committee sponsored event on fair housing training on emotional support animals. At this time, I'd like to introduce to you our Director of Public Policy here at NAA, Nicole Upano. Nicole's going to give a presentation on the topic, and then we'll leave a few minutes at the end for some questions. If you do have questions, please look for the Q&A box that you can find at the bottom of your screen. Click in there and type your questions in, and that's how we'll receive your questions for the end. And with that, I'd like to turn it over to Nicole.
Thanks, Ron. Good morning, everyone. Thanks again for having me today to discuss your favorite topic and mine, emotional support animals. Before I go into my presentation, I just wanted to stress a couple key takeaways. So your company should have written policies on how you handle reasonable accommodation requests for animals. And you should document this process by which you implement your policies at the site level. So to help you operationalize this process, I highly suggest that you utilize the NAA toolkit and the forms that are included therein. All of that information is on the NAA website, and I think Jen or Ron will get you copy of the toolkit, and also we'll let you know where you can find that on the website as well. So you want to remember that you need to apply your policies and your procedures evenly amongst all individuals. And that's whether you receive the request by phone, via email, or in a face-to-face conversation. And this is really important, especially for fair housing testing, because no matter where the request comes from, that's what really will get you into trouble. If you are allowing resident A to do something, yet you're penalizing resident B for the same thing, that will definitely get you into trouble with HUD or your local fair housing group. So remember that consistency is key. I also want to stress some other best practices right off the bat. You should, when you get a phone call and the caller asks you if you allow emotional support animals on the property, never ever say no. That's a common testing approach that, like I said, could get you caught up in a complaint. And like I said, never ever say no. Another common testing approach is for the caller to say, I have an emotional support animal pit bull. Would you still be willing to rent to me, or do you still have a unit available? And again, you never want to end the conversation there. You want to keep that conversation going. This is actually something that is protected under the law. It's called the interactive process. You're required to engage the applicant or resident in this back and forth conversation just to determine whether you can accept their accommodation or not. So when someone approaches you or your staff about a reasonable accommodation request, your canned response should be something like, your company complies with all applicable fair housing laws. You have a process that you use to evaluate requests for an accommodation, and you should invite them again to a face-to-face conversation where you can walk them through that process. Another key takeaway is whatever your policy is, make sure you're documenting everything in the file. It will help you later on down the line, like I said, from a fair housing perspective, just so you can have documented why you approved or you denied an emotional support animal request, or for another example, why you denied an applicant based on your stated screening criteria. So this will make it clear that what the non-discriminatory reason is for why you came to your conclusion, should you be challenged or subject to a complaint. Next, I'd like to go into some of the basics on the federal law on what you can and can't do under the Federal Fair Housing Act. And for this webinar, we're going to take into account the relevant guidance from HUD and DOJ, but you should also note that there are other applicable laws to this issue. For example, the Americans with Disabilities Act would cover the leasing office. It would cover anywhere that's open to the public. So if you allow the public to use the pool, that might also be covered by ADA. Also, residents, any requests from a resident's guests may also be covered under the ADA. At the end of the presentation, I'll briefly touch on the state and local fair housing laws that may overlay some additional requirements on top of what we discuss here. And if you have any questions about that, I highly recommend you contact your local affiliate or you seek the legal advice of local counsel. They're the best equipped to help you. So let's go ahead and get started covering some of the basics of the law. So as a reminder, the Fair Housing Act covers 7 protected classes. That is race, color, religion, sex, familial status, national origin, and disability. And our conversations here today really focus on that the last protected class. One of the prohibited acts of discrimination under the Act related to disability is the refusal to make reasonable accommodations. Now, a reasonable accommodation is a change in the rules, policies, practices, or services, basically making an exception to these for a disabled person that is necessary to afford that person with a disability the equal opportunity to use and enjoy their dwelling or their housing. An example of this would be a reasonable accommodation for a resident who wants an animal in a no pets building. I also would like to note that the Act applies to all publicly owned and privately owned housing. There are a very few limited exceptions. You would be exempted from the Fair Housing Act if you operated a building with 4 or fewer units and one of those units is owner occupied, or if you're operating single family homes sold or rented without the use of a broker. The Act also exempts housing operated by religious organizations and private clubs that limit occupancy to their members. So the federal law covers what HUD refers to as assistance animals. So what is an assistance animal? An assistance, I think you should think about this as an umbrella term that covers both service animals and emotional support animals. And you should think of an assistance animal as a device that assists a person with a disability to help them in their day-to-day. It's like a person with a disability who's using a wheelchair, for example. So an assistance animal is an animal that either works or provides assistance, performs a task for a person with a disability, and that's commonly referred to as a service animal, or it also covers emotional support animals, which by definition, these types of animals provide emotional support that alleviate one or more identified symptoms or effects of a person's disability. I want to stress here that the law does not require an animal to be trained or certified. It does not require. So, while many service animals are trained to perform a specific task for a person, you can't deny solely on the basis that the animal is not trained or certified. On the other side of the coin, if you have a resident come in, they bring in their certified emotional support animal registration card, their certificate, they have a vest for their animal, and they say that on its own or on its face shows that they should have this animal in their unit, I would say that those are red flags, and it's probably not a legitimate request. Other considerations for what an assistance animal is you should remember this is not a pet. Never refer to an assistance animal as a pet. This could get you in a lot of trouble. Let the resident use the term that they want to use. Just make sure that when you're deciding whether to approve or deny the animal, that you know what is defined under the law and what is covered under the law. So what is an assistance animal? What is a service animal? What's an emotional support animal? And remember, an assistance animal could be any type of animal. It could be a snake, it could be a rooster. There are, dozens of types of animals that it could be. More than likely, it's going to be a cat or a dog or a bird or something of that sort. We'll talk about how to deny individual animals later, but just remember they come in all forms. And another key consideration for you to know is breed, size, and weight restrictions that you may apply to pets. You cannot apply to an assistance animal. Remember, that's like applying a restriction onto a disabled person's wheelchair. That's essentially how they're thinking about it. All right, so when you're trying to decide how to handle a request for an animal, you need to ask yourself 2 questions. Does the person seeking the reasonable accommodation request, do they have a disability as defined under the law? Do they have a physical or mental impairment that substantially limits one or more major life activities? And remember that word substantially. And does the person making the request have a disability-related need for their assistance animal? So in terms of a reasonable accommodation, you might hear the term nexus used. And as part of your process, you want to determine, does the person have a disability, and does the person, is there a nexus between their disability and their disability-related need for their animal? For example, a resident might stop you or stop a maintenance man on the property and say, you know, my eyesight's going, I'm going to need an animal to help me get around. And you should know that a request can come verbally or written, and so they've already started that process when they've made that verbal request. And remember that it's a big, big, big no-no to ask the person about their disability. You never want to ask what it is. This is especially for the disabled person hurtful if they're asking for an emotional support animal and they have some sort of mental impairment and you're questioning why they even need the animal. I used to take the classes that investigators of fair housing claims take, and they give their clients a form to determine damages. So every time you ask the person, or you say, oh, you refer to the person's pet, or you say, oh, do you really have a disability? They're counting those as separate incidents that could be taken, could be held against you when they're trying to determine damages for the aggrieved party. Also, remember the interactive process. Your first response should never be a hard and fast no. You want to engage them in the policies and procedures that you've put into place to decide whether to take the animal or not. One related question that I commonly hear from our members is, my community limits the number of animals to 2. What do I do if a resident has 2 pets and then asks for an emotional support animal? And I'd like you to think about the first slide for a moment. What is a reasonable accommodation? It is a change in the rules, policies, practices, or services that is necessary to afford the disabled person equal opportunity to use and enjoy their dwelling or their housing. So with this in mind, you would be required to consider a request to make an exception to that 2-animal limitation. So keep that in mind, but also keep in mind that the law covers reasonable accommodations. So if you have a situation where the resident already has 2 animals, they're now saying their spouse or their child needs 2 animals in their small apartment, you can take all of this into account. This might be grounds to push back on the reasonableness of the request, and you could justify requiring the requester to get rid of one of the existing pets to be able to allow that assistance animal. Also, I want you to keep in mind that this, like I said, the request could be verbal or written. So in whatever format that you get the request, acknowledge that they've made the request to you. Use this as an opportunity to start the process with them. While the resident may make the request verbally, you can ask them to fill out the appropriate forms or paperwork that you have put into place for these types of requests. Again, you want to follow the same process that you do for everyone and make sure that you have all the information you need to process that request and that you're documenting everything in the person's file. All right, let's go into some of your rights under the law. When can you ask for supporting documentation? So you can only ask for supporting documentation if the disability or disability-related need are not readily apparent. So I want to give you an example that does not fall under this case. If you have a seeing eye dog, for example, the person comes into the leasing office, they very clearly have, sunglasses, they have a cane, and the dog is clearly guiding them or helping them on their way. You cannot ask for documentation. You can see on its face that that person needs their animal to get by in their daily life. On the other side of the coin, in most cases for an emotional support animal, the disability or disability-related need are not readily apparent, so you can ask for supporting documentation. Now, as far as the doctor's note, who can write the note? Can an owner require that the documentation come from a licensed physician? No, you cannot. a doctor, another medical professional, a peer support group, a non-medical service agency, or a reliable third party who is in a position to know, and this language comes directly from HUD's guidance, any of those people can attest to a person's disability and provide the necessary verification. So what about, under what circumstances can an owner deny a reasonable accommodation for an animal? So according to HUD, the request can be denied if doing so would impose an undue financial or administrative burden, or would alter the nature of the housing provider services, or the specific assistance animal in question poses a direct threat to the health and safety of others that cannot be reduced or eliminated by another accommodation. Or, in other words, when you talk about if the animal poses a direct threat, you need to determine based on an individualized assessment of that animal whether that animal is a danger. You can't just rely on the idea that pit bulls are dangerous, they tend to bite people. That will not suffice. If you are subject to a claim, that could definitely get you into trouble. You need to make an individualized assessment on that animal. Did you come into contact with the animal and you notice that they're snapping? Have you gotten complaints about the animal from other residents? That sort of thing. That would help you make the best assessment. And in regards to other reasons for denial, you could also, one of the other reasons is, does the specific animal in question, would it cause substantial physical damage to the property that can't be eliminated or reduced by another accommodation? So for numbers 2 and 3, I've sometimes seen those used. For number 1, the undue financial administrative burden, that's very rarely used, and most owners very rarely can get away with using that as the reason for denial. In my experience, for reasonable accommodations, that's only been used when you're asking for a member of the staff to, carry the person's groceries every day, bring them their mail every day. That would fundamentally alter the nature of your business. But as far as using that reason for denial for animals, it's very rarely successfully executed. Another reason that's not specifically stated in the guidance is reasonableness. Like I mentioned before, if you are being asked for an emotional support animal boa constrictor or that sort of thing, that is a legitimate reason to ask for more information or to question that. You are required under the law to make reasonable accommodations. So just to go over this again, you cannot deny on the basis of an animal's breed. As I've said before, if you're basing your denial on the idea that pit bulls are inherently dangerous, that will definitely not fly. You need to have some documented evidence of your individualized assessment of the animal that helps you reach the conclusion to deny based on danger to the property or to the other individuals. You cannot apply generally breed, size, or weight restrictions to reasonable accommodation requests. So what if a resident asks for multiple animals? It is allowed under the law for the person to ask for multiple animals. A common example would be if you have a veteran who has mobility issues, but also has mental impairments, has PTSD or something of that sort. They may ask for a service animal to help them get around, and also an emotional support animal that helps sort of alleviate that everyday stress of PTSD. And that is allowed under the law. But like I said, in other cases, you may also consider reasonableness in allowing multiple animals for multiple people in the unit in, let's say in a small apartment. That's a legitimate concern. I think I already kind of went through this. Again, I would turn to the reasonableness argument to determine whether this is allowed, but just just to reiterate, an individual is allowed to ask for multiple animals for themselves or for someone who lives in their unit. What about pet fees and pet deposits? What about liability insurance if you're worried about the animal biting someone? I would just encourage you, again, to look at the guidance and look at the toolkit. In HUD's guidance, it is explicit that you cannot charge pet fees or pet deposits, pet rent, anything for that animal, because as I've said earlier, this is considered a device to help someone with their disability. And so you cannot assess anything as if it were a pet. As far as liability insurance, this is considered an additional requirement on top of the reasonable accommodation, which is not allowed. So you cannot require liability insurance. As far as damages, I will say that you can charge this to the security deposit upon move out. If there's a larger claim for damages, that could go to small claims court. That sort of thing is allowed. If you're doing that, if like a security deposit is assessed on everyone on the property, you can charge that to the security deposit. As far as animal, I know some owners have a pet addendum that they require everyone on the property to sign who has an animal. I would suggest that if you have a pet addendum, that you should change the language to animal addendum so it makes clear that it applies to all animals on the property. If it's just for pets, per the language of the policy, then it's just for pets for the animal addendum. But you are allowed to have an animal addendum which says the resident needs to pick up after their animal, and they must be in control of that animal at all times. If they're barking at all hours of the day and night, they're causing a serious disruption, the resident would still be subject to eviction for lease violations or for non-compliance if they're not complying with the terms of their lease. So can you restrict the animal from the common areas, like the leasing office, the pool, or the pool area? According to HUD's guidance, the animal must be allowed to go wherever the person may go. So they must be allowed in the leasing office, the common areas, or the pool. With that said, there are some local health codes that prohibit animals in certain areas where food is being prepared or in the actual pool. So you may or may not be able to rely on those. There could be some exceptions to that. I will say, if, for example, you have a person who has a doctor's note that says, my patient has seizures, they need their animal wherever they go to alert them of an impending seizure, it would be very difficult for you to push back and deny that on the basis of not allowing that animal into the pool. So if you're in a situation like that, I'd highly recommend that you contact local counsel. All right, so let's talk about verification for a moment. Are you allowed to call the provider to verify the information that's on the form that you've asked the resident to sign? And I'm talking about the forms that are in the NAA toolkit, for example. The answer is absolutely yes. According to federal guidance, owners and operators do have the right to verify the authenticity of the documents you're receiving from the resident. I will say that we're hearing from owners in other parts of the country that fair housing groups are pushing back on this, so I just want you to be aware. There's one fair housing group out of South Carolina telling owners that if it looks legitimate on its face, then you must accept the verification. We at NAA have found that more often than not, you'll get a note from a doctor or from a website that doesn't give you all the information you need to process that request. For example, you really need that information to determine, does the person have a disability and do they have a disability-related need for the animal? So if you don't have this information and it's not made clear in the note that you received, you should follow up with that doctor or whoever provided the note. So NAA members are reporting that the most effective way to cut down on abuse is the verification part of this process. So for example, if you get a note from a doctor saying, it would be nice if you allowed my patient to live with their animal, that doesn't necessarily line up with what you need to determine in your process. So you should follow up with the doctor, and you may find out from the doctor, they may say, well, my patient doesn't really have a disability. It would just be nice for them to have. And again, that doesn't line up with what is required under the law. Another example is if you get a note that was clearly purchased from the dog tour or another one of these online mills, I would, if you can't get a hold of the provider by calling the dog tour or one of these others to verify, that could be grounds for you to ask for more information. More often than not, the resident won't be able to provide another form of verification, so it's effectively a denial. So just another reminder, you should have a documented policy and make sure that you've educated all the staff and all the residents on this policy. You want to, like I said, enforce the policy evenly. And I just wanted to put in another plug for the toolkit. Like I said, the toolkit's full of a lot of really good information, a whole slew of frequently asked questions. We took the HUD's guidance and all relevant materials and broke them down into a list of frequently asked questions. In the toolkit is also scripts that you can use to educate your staff on how to handle requests. For example, it gives information on, what do you say to resident A when they've seen resident B in their no pets building with their animal? How do you handle that situation without violating resident B's privacy? That is also covered. Also in the toolkit are forms that you can use, and these forms include a model reasonable accommodation policy. They also include an animal identification form and a form that you can use to verify with the provider. And all of this is included in the toolkit. So yeah, with all of this said, if you have a resident who provides you with all that necessary information, everything that's in the letter, for example, just going back to verification again to close this out, if on the off chance you get a letter that says, I'm prescribing an emotional support animal for my patient. He's a veteran with debilitating PTSD. His dog Ace helps to keep him calm when he experiences stressors in his life. It's going to be hard for you to deny based on not having all the information in the letter or to require verification in that case. So before I close out, I wanted to leave a couple minutes for questions, but wanted to have give you a couple more tidbits of information. Wanted to give you a sense of what's going on around the country. So there are now 28 states that have laws on the books that make it unlawful to misrepresent an animal as a service animal or fraudulently represent oneself as needing a service animal. Some of these state laws are also applicable to like we talked about earlier, the broader category of assistance animals, which covers emotional support animals. But we found all across the country that whether the law says that it's just for service animals or whether it's been expanded, both approaches have been used to deter applicants and residents from requesting reasonable accommodations for animals under false pretenses. Because as I've mentioned earlier, most people don't know the difference between service animal, emotional support animal, therapy animal. So you should just be aware. Wanted to also let you know that for these 28 states, some of the laws, I know Indiana in particular is more stringent than what is allowed at the federal level. So I would highly encourage you to reach out to the affiliate on how to handle this and also seek the advice of legal counsel. What about action at the federal level? So action at the federal level, the latest is that, to our knowledge, HUD has new emotional support animal guidance coming down the pike. It has not yet been released. It's still going through a very complicated vetting process through HUD and through the administration. And as soon as we have that information for you, we'll update the toolkit and update the materials. NAA has been at the forefront of going to HUD and to the administration about this issue to let them know that members have significant concerns about the current guidance and why it has allowed for loopholes to have exponentially significant growth in abuse in the last couple of years. I think you've already probably seen this in the airline industry. That really helped highlight for us to go to HUD to say that there are problems with the law and it needs to be changed. All right, like I said, I highly encourage you to use the toolkit on this on the NAA website, on the emotional support animal page. It also includes recordings of previous webinars. Kirk Cullimore, who wrote all of the forms in the toolkit and graciously allowed us to use them and make them available to members. He gives some more deep dive background on how to handle individual issues, that sort of thing. So I highly recommend you going to the NAA website and reviewing the webinars and things. And also, please feel free to use the forms in the toolkit. I know there's a legal notice at the bottom of them, but Kirk has allowed us to use those forms in the toolkit so that everyone can use them. We just ask you not to make any changes to those forms if you're going to use them in your day-to-day. All right, that is all I have for today. I think I went over 2 minutes. I'm sorry about that. Just going to see if we have any questions. Do we have any questions from the group? All right, well, thank you so much for having me today. I really appreciate it, having your time. Please reach out to me if you have any further questions, and thanks again. Happy holidays.